While some say that the Union Budget 2015 was a landmark budget, others, specifically real estate, says it held absolutely nothing for them. Well, even if we forget about the industry for a while and just focus on the consumer, there are some tax provisions which begged for the finance minister's attention but got none. So check out some of the provisions of Income Tax Act that are stacked against the property buyers. I'm going to start with one which has been a huge issue with everybody, especially because projects get delayed and consumers or buyers do not get possession for 5, 6, 7 years. So 3 years is just not happening anymore. This is 24B, availing deduction on home loan interest paid for an under construction property. If someone buys an under construction property and that project is not completed in 3 years, he cannot claim interest paid on home loan as deduction from his income. Now, could this have been fixed? Vinay Singh, founder and owner, Vinay Singh and Associates and property expert, joins us. Vinay, I mean, you speak very, very clearly and very plainly. So tell us, isn't this so stacked against the buyer? A, the developer is refusing to honor his commitment. Developers also charge him 18 to 24% interest, but pay him only 5 rupees per square feet for delays. And then on the top of it, that 2 lakh limit is also unusable till you actually get the possession of a house, which doesn't come in less than 5 to 6 years. Could this have been fixed?
Yes, actually, it's a double whammy. Firstly, there is no reason not to allow the interest even though the possession has not been taken. What is the reason? If I have taken a home loan and I am paying interest on it, I think I should be allowed regardless of the fact whether or not I have taken possession. Number two, the way this law is framed as of now, all your past interest prior to the year in which you take possession will be allowed to you at 20% per year over a period of 5 years from the year in which you get possession. But here too there is a catch. That 20% of the total interest prior to your year of possession plus the interest that you are paying in the year of possession is subjected to a cap of 2 lakhs. So, you know, again, there is a bit of, how can I put it, there is a bit of meanness, I would say, on the part of the drafter, that you're not allowing me the interest, and then when you're finally allowing me, it's eating into my annual allowance of 2 lakhs again.
So, Vinay, this has been a demand from the buyers for a really long time. And in subsequent budgets, we've seen no action. Isn't it? So what do you think the government is missing? Is there a fear there that we will probably be supporting more investors? What do you think could be something that we're missing out, which the government sees but the buyers can't see?
I don't think there's any real issue, because if you're going to allow 2 lakhs of rupees a year, where is the issue in this? How much of exchequer is going to lose in terms of taxes on account of allowing 2 lakhs? I don't think it's an issue. It's probably just that somebody has not bothered to apply their minds. I think last year we discussed that where should this limit of 2 lakhs should have been. Right. And I was saying that it should have been 10 lakhs, because considering the way the prices have galloped and the amount of loan that a person is taking today to buy the same house, say compared to what he was paying 7, 8 years ago. So accordingly, this limit also should keep pace. Today, I mean, a decent flat, you would be taking a loan of 70, 75 lakhs. So that means what? At 10%, it would be 7.5 lakhs for the first year. You're giving only 2 lakhs.
All right.
So I don't think it is sufficient. Somebody needs to take a hard look at this and plan it properly, I think.
Fair enough. Okay, so next provision, which also is now becoming a bit of a bane on the buyers, when the actual value of property is less than the circle rate, section 50C, the valuation assessed by the stamp duty authorities will be considered for computing capital gains on transfer of land or building or both. Now, I do know, Vinay, that for a long time there was a huge gap between circle rates and actual transactions of property in many locations across the country. And that actually left room for a lot of black money to happen. But in the last 3 years, that gap has bridged considerably, and in some cases, property values have fallen and circle rates have gone above. So here, I'm just wondering, was there a way that the government could have been fair in a way that you don't encourage black money transactions, but also not penalize a seller who's actually not realizing circle rates?
See, if you see, Manisha, from October we are seeing this trend in Mumbai. 2 years back, there were many areas in Mumbai itself that I was aware of where the market, where the reckoner rates were about 1/3 of the market rate. Then it started inching towards 50% of the market rate. But now suddenly we are finding that from October of 2014, the trend has changed and the reckoner rates have actually overtaken the market rates. So this is going to create a severe problem because whatever you may say, finally the income tax officer is going to take the reckoner value as the sale value, and today that applies to builders as well. Earlier the provision was that it was not applicable to builders, but now the new section was introduced a year ago and that now applies to builders as well. So it's going to become extremely difficult for the common man that he is selling something, but he finds that his tax liability has now suddenly gone up. Not only that, it also has an impact on the other party. That difference, the gap that is there between the market price and the reckoner value, he also has to pay tax at 30%. So it's not a very good provision. Unfortunately, the reckoner value is set by the state government. Now, one way of solving this could be that they could review the reckoner rates every quarter and adjust them every quarter. If you feel the prices are falling, then change it every quarter. This is an annual exercise which is actually causing the problem.
Yeah, but you know what, Vinay, to get the government to do something annually itself takes so long. Imagine trying to get it done every quarter, but then that's the market. Market is volatile and you have to completely adjust to it. Okay, so you've pronounced that both of these things are extremely unfair. So let's go on to the third one, which from a buyer's perspective also doesn't seem very logical. Long-term capital gains, Section 54 and 54F. Realized from the sale of residential property or any other capital assets would be exempt if the entire amount is invested in purchase of one residential house within 1 year before or 2 years after the date of sale, or construction of one residential house within 3 years. So this amendment actually happened in 2014. What do you think when there was a logic? Because, you know, I might sell a property which is worth a lot. I might want to buy 2 smaller properties for 2 of my children. Why would the government restrict it to one house? Because the sum doesn't change, isn't it? If I've made 1 crore capital gains, why restrict me from buying only one other property?
Actually, there never has been any logic to this. Now, unfortunately, Section 54 and 54F said that you will get a set-off against your capital gains provided you invest in a residential house. Now, this term a residential house has been the subject of much controversy and much litigation. I think for close to 40 years, 50 years, the government actually did nothing about it. They let that litigation proceed. Now, in Mumbai, what has happened is that a few years back, there was a tribunal judgment which said that it doesn't matter how many units you purchase, but so long as you have combined those units and you are using that as one single unit, one contiguous unit, so the deduction should be allowed. So now there are cases from other cities as well. Some places 5 units have been combined into one, some places 2 or 3 units have been combined into one, and the courts and the forums have been holding that this is permissible. Now suddenly out of the blue to restrict it to one flat would mean that I can't combine more. That is the stand I presume that the income tax department would take. And there is really no logic for it. If I have made capital gains, let me buy 2. Families are growing. It is no longer a case that everybody wants to live in a joint family. Nuclear families are increasing every day. So there's no real reason why this benefit should not be extended for multiple flats. You can put a clause that, you know, it should be for the same family or whatever it is.
All that we can say is that all of this sounds so illogical. I'm wondering why the government isn't focusing its attention and just making these small changes. But then we've heard from the finance minister that budget is not the only time that his government works. It's going to work around the clock and round the year. So hopefully, who knows, there could be change in provisions if we continue to lobby hard and highlight these issues. Vinay Singh, thank you very much for joining us here. Always a pleasure to have you with us.